Well, good afternoon, Michiganders. It is Tuesday, April 14th, and this, of course, is Tuesday with Tom, Michigan's only weekly internet show where we do answer your questions about estate planning and estate settlement in Michigan, and we don't send you a bill. I'm your host, Tom Doyle, estate planning attorney, lifelong Michigan resident, and ambassador for all things good in this great state of Michigan. Welcome to today's program. Last week's episode. Perhaps you have a life insurance policy and you are considering selling the policy. I know there have been a number of television commercials on lately concerning different companies that will be interested potentially in buying your life insurance policy. If that's something that you're thinking about, or you know someone that's thinking about doing that, I would suggest that you listen to last week's episode to hear some of the discussion about things that you need to be concerned about if, in fact, you do decide to sell your policy. Today's show, something that happens perhaps less frequently, maybe than it did years and years ago, but we've got lots of clients out there who have safe deposit boxes at their credit union or their bank. Although I find over my last 40 years, it seems that fewer clients go out and get a safety deposit box, but you might have one, or you might have a loved one who has one. And so today we are going to talk about how you would access that safety deposit box after the renter's death. But please remember, what I'm about to discuss during the program is, as always, for educational purposes only. It is not intended to be legal advice. You need to work with your attorney to determine what is appropriate for you. Okay, so perhaps you have a loved one who's recently died, and you go to the bank or the credit union, and you want to get into the safety deposit box, and they don't allow you to have access. What are some of the options that would be available to you? And normally what the bank or credit union is going to say to you is, well, hey, go open a probate estate. Just go open a probate estate like it's a simple, easy, inexpensive thing to do. Well, let's talk this afternoon about some of the options that might be available to you, but let's go back one step before all of this. Let's assume that you have a safe deposit box and you're looking at putting your estate plan together. You have to ask yourself, how is it that the person who's going to be responsible for settling my estate is going to be able to get into my safe deposit box? So in advance, there are some things that you should at least give some consideration to. One, obviously, is to make them a joint renter. Husbands and wives who have joint estate plans, Norm will look at having a safety deposit box that's going to be jointly rented by the two of them, so that if one of them dies, the other is going to have access. Unfortunately, though, I had a client recently that we were dealing with whose wife went down and got a new safety deposit box, and he simply never got around to putting his name on it, and she passed away. So if you're going to be joint on the box, make sure you get that taken care of. Another alternative to explore with your bank or credit union is if you have a living trust as your estate plan. Will they permit the living trust or the trustees of the living trust to be the renters? Will they allow it to be set up so that if the trust rents the box. Anybody who is serving as the trustee of the trust will be able to have access to the box. That's some conversation, though, that you will have to have with your bank or credit union, because not all of them will allow a safe deposit box to be rented by a trust. But it's trying to be proactive in advance. If you're going to have a box, think about how is it that somebody is going to be access that box after the time of your death. And you might have a power of attorney, and your power of attorney might have provisions in it giving your agent the ability to access your box. But what you have to remember is this: your power of attorney ends upon your death. So a power of attorney that you've used to give somebody authority to access that safe deposit box is not going to allow them to do so after the time of your death. So let's talk about a couple options where someone has, in fact, now died and was the only person on the box, and now you're the surviving spouse or the children or whoever it is that's supposed to be responsible for settling the estate. How can you obtain access to the safe deposit box? Well, the good news is that in Michigan, through the probate court, there is a process. There's a form. It's called the Petition in Order to Open Safe Deposit Box to Locate Will or Burial Deed form. That's a Form PC 551. If you want to look that up on the internet, simply go to Michigan Probate Forms, look up form number PC 551. That form is the form that the probate court uses when somebody needs to get into a safe deposit box. But the only thing that form allows you to do is to get access to the safe deposit box to find out if there is a will or a deed to a burial plot, so that you can get the will or the deed to the burial plot. So it's very limited in what technically the form allows you to do. What do? Well, you fill out the petition, you file it with your local probate court. I think it's about a $10 filing fee currently. And the court will process it. They'll send back the court order, and you will now take that order to the bank or the financial institution where the safe deposit box is located, and you present it to them. And per the order, they now have to give you access to the box. But again, only for the purpose of removing a will or a deed to a burial plot. In fact, once you have opened the box, the bank or financial institution is required to file its own form with the probate court. And that is a safe deposit box certificate. And that form filed with the probate court indicates whether or not they did find a will, whether or not you did find the deed to the burial plot, and specifically indicates in that form that no items or items other than the deed or will were removed from the safe deposit box. So if all you're trying to do is locate a will and or a deed to a burial plot, that is how you would go about doing it, using the petition in order to open safe deposit box. Now, certainly what some people are going to do, they're really going to use that petition in order to at least open a box and see, does it look like there's anything else in there Maybe there isn't anything in the safety deposit box. I've had those. They're empty. Maybe that's all you're going to find out, or maybe you're at least in that process going to determine that, yes, there is something else in the box. Maybe there's deeds to real estate. Maybe there's other important papers, and then you're going to have to look at what's going to be your next step in order to then access those things other than the deed to the burial plot or the will. So, what is the next step or the alternative step? Maybe you don't want to do the first one because you already know that there's something in there other than a deed to a burial plot and a will. You already know there's going to be something in the box. And so you don't want to, quite frankly, waste your time and money filing a petition if there's another option. Well, there is another option. And that other option would be another type of probate that's available in the state of Michigan. And this is a probate where you have a fairly small estate, less than $25,000, and it's what's called a petition in order for assignment. Again, there's a form number for that. That's a PC 556 if you want to look up the form. And essentially, this is a form that you use in order to get a court order requiring assets to be distributed to certain people that are reflected in that form. At its core, the idea behind the form is this. In the state of Michigan, anybody who pays somebody's burial expenses, funeral and burial expenses, they have the right to be paid before anybody else gets paid. Funeral and burial has the right to get paid. So the idea starts out behind this form is, hey, are you somebody who paid the funeral and burial expenses? If so, you can look at using this form as a tool for getting a court order requiring somebody who has control over the decedent's assets to give you those assets, to reimburse you for the cost of the funeral and burial expenses. Second, you're the spouse, and you have certain rights of inheritance as a spouse, so you can use this form as a way, as a spouse, to get a court order requiring assets to be provided to you. Or perhaps you are another heir. Maybe there isn't a spouse, and maybe you're children. And as children, you're the heirs. So whoever the legal heirs of the deceased person might be able to use this form. But the idea is the estate is a small estate. The total estate is less than $25,000. This petition gets filed with the probate court. In the petition, you will identify the different property that you are aware of that the person owned, both real estate and personal property. In the petition, and this is very important, in the petition you have to indicate the funeral and burial expenses, how much they were, and this is one that becomes very important, you have to attach to the petition a copy of the receipt reflecting that you, the person who's filing the petition, paid for those funeral and burial expenses. Why? Because, again, that person has a right to be paid first. So if somebody else paid the funeral and burial expenses, and you fill out the petition in order, first, whatever assets there are have to be used to reimburse that person who paid the funeral and burial expenses. And then you're going to list out, as I said, the real estate that the person had and any other personal property that the person has. So let's now look at it from the standpoint of a safe deposit box. You could list out under description of personal property what is in that safe deposit box. Maybe it's a deed to real estate. Maybe it's a title to a car. Maybe it's some jewelry or some other personal property that's in there. Normally, I would recommend something along the lines of a description of personal property in a safety deposit box would be all contents of the safe deposit box number such and such, located at such and such bank, including various legal documents, papers, and miscellaneous jewelry and other tangible personal property. The idea is to be broad enough that it would cover anything that is in potentially that safe deposit box. You file that with the probate court. Probate court processes it, and if everything is appropriate, if you are the right person to file it, then you'll get a court order back. And essentially what that court order coming back to you is going to say is, hey, we are ordering that the funeral and burial expenses in a particular amount get reimbursed to the name of the person who paid them. The court is ordering anything beyond funeral and burial expenses would get paid to the surviving spouse. And the court can further order that anything beyond funeral and burial, and if there isn't a surviving spouse, then anything else would get paid to the heirs. And heirs has specific meaning under the law in the state of Michigan. But you'll have a court order. You could then take that court order, in this case, to the bank or the financial institution, present it to them. And if you present to them an order from the probate court requiring them to distribute the assets, in this case, that are in the safe deposit box, to the person who paid the funeral and burial expenses or to the spouse, or if not the spouse, to the heirs, it then has accomplished your goal of acquiring whatever assets there are in the safe deposit box. Unfortunately, you might find your bank or your financial institution not being satisfied with this process, but they should. It's a court order, and it's ordering whoever it is that has possession of those assets to distribute them per the court order. So that's option 2. Option 1, the petition to open the box simply to get the will or burial plot. Option 2, the petition in order for assignment. Again, keep in mind that is only available when the total assets are less than $25,000. So when you're filling out the form, you have to put a value on what those assets are in the safe deposit box. So think about that, because you're going to indicate what the funeral and burial expenses are. Let's assume they're $5,000. That means you can only have another $20,000 of other assets or real estate that would be subject to this process. If none of those apply, maybe you have a larger estate than that, then you're going to be looking at opening up a traditional probate estate. And let me step back 1 second, too. The petition in order for assignment, it's really designed for people to do it without attorneys, although you can hire attorneys. There's a place for attorneys to represent somebody, but normally the cost of doing so is pretty steep. So the process is really designed for people to go forward and do it without having to hire a law firm. But the third option is to open a traditional probate estate. You're going to hire someone like Amanda, who's going to petition the probate court, all the normal documents that are used in a traditional probate estate are going to be used there to get that estate open. To get your letters of authority, once you have your letters of authority, then you can present those to the bank or the financial institution to get access to the box. Now, the traditional probate estate, as we will tell clients, Normally, it's going to run probably somewhere in the neighborhood of $4,000 to $7,000 ballpark by the time you end up paying attorney fees for the lawyer who's going to be doing the work for you. But perhaps once you get into the safe deposit box, it might be determined that the value of the estate is small enough that it can be fairly quickly closed as a small estate. So it might be a possibility. If the only thing you're doing is getting the safe deposit box, it might not be that $4,000 to $7,000. You might actually be able to close the estate out sooner than the normal probate estate. But that will only be determined once the probate estate is open and you have access to the box and you see what other assets there might be. Now, that should go without saying, too. If, in fact, you already have to open a traditional probate estate, well, then that's the route that you're going to go. You would not open a traditional probate estate because there's assets that need to be probated and then do the petition to open a safety deposit box or the petition order for assignment, because you'll already be accomplishing everything that you need to do through that traditional probate estate. So, in summary, try and think in advance of your own estate if you have a safe deposit box, how it is somebody's going to have access to that. If that hasn't occurred, there might be some options. Well, there are different options available. One's going to have to determine what's going to be the most appropriate option for you to proceed in getting access to that safe deposit box. Well, that's going to be it for today's show. As always, of course, though, if you have a comment about the program, perhaps a question that you would like to have me answered, or a topic that you'd like to have me discuss. Look at all the different topics that we've covered since 2016. And if there's something that we've missed or something that you'd like us to update, then simply send me an email, tom@tuesdaywithtom.com, or mail me a postcard, Tom Doyle, P.O. Box 16066, Lansing, Michigan 48901. And of course, please follow us on Facebook and Twitter. That would be Tuesday with Tom. Follow the office as well at Doyle Law PC. Remember, too, that Tuesday with Tom is the app, the Tuesday with Tom app, that is available in both the App Store and Google Play. Of course, the program, as always, is available in Apple Podcasts, and you can always ask your smart speaker to play Tuesday with Tom for you. And of course, not to give an extended commercial break, but please remember, too, though, that Amanda and I would be honored to have the opportunity to help you protect your loved ones by putting together your estate plan, amending a plan that you have, or assisting you in settling your estate. And of course, during this time of uncertainty, we are happy to provide estate planning services to you from your home using our Planning from Home service, where you don't have to leave your house and the estate plan can be prepared for you. Simply go to DoyleLawPC.com and click on the Planning from Home tab for more information about that. If you're a current client, make sure you visit the virtual office also at the website, where you're going to find the ability to update your estate plan simply through the website, schedule an appointment, telephone consultation with us through the website as well. Well, thanks again, though, for spending some of your Tuesday afternoon with us today. And as always, I hope that you have an awesome day and an awesome week in Michigan. Stay safe. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.